This is a Pest Management Task Force meeting, July 18, 2012 at 9:30.
That's one thing I did. So you have words.
They did change one. You know, I have a bunch of inspection work on the last and I can read it.
How that's something. Oh, are you?
Yeah. My deal. Just come, I mean, I've got it for me 5 years doing that. That's because I'm trying to skill.
I know. Yeah, definitely. Oh, did they when they go back?
Yeah, but we won't be on time.
What did they do?
They don't want to give you an excuse.
Oh, okay.
What's that? Big time. I take over. Are you going to get everything? What?
We don't do a whole lot of
What?
I don't work here, like my father was, I worked all these years.
What are you?
My wife makes it very clear to me that when I get out of the shower, I need to scalp all of that.
I don't want to. I'm just starting.
Especially if you want to shave it off. We can't start yet because we don't have a quorum.
Oh, are you going to say that?
Jimmy's sick. And Phil was not here.
He's at a funeral. Yeah, Kirk's on his way here.
Kirk is okay.
Yeah, he had a human resources meeting. Told me so. I called him.
Maybe I was amazed.
What?
Good morning, how are you?
Yeah, how much are these?
Howard says that with PCA, and then we got new PCs throughout the office during anywhere from 2 years up to
He runs his stuff for me.
so. But I wanted to order purchase. It's like kind of usually running phones right. So I can't talk her. And then we're not going to install.
Right.
I know. I know she has.
said.
She had to look up this word.
Half the state is allowed.
I just don't know.
That's why I.
Remember, we were discussing that earlier.
Just don't use the Wikipedia. I hear one more comment about Wikipedia. It's unreliable.
Well, I know it is, but there are a lot of, you can get general information normally. Like, you can try it, that's what it says on Wikipedia.
I don't think he really needs to say that.
Where a city is, what county it's in.
Plus people coming down the street.
That's what.
Yeah, certainly what's going there. I think so.
8,200.
I got all
Yeah, you're leaving.
Congratulations.
I should see your.
I am.
Have you seen
I am very confident.
8 minutes.
8 minutes. Again, while we're waiting, George, you're waiting for a quorum of the task force. Until they arrive, you can't get started.
The next day, my wife's favorite.
48 ounces was up to non-profit. Like, goes up.
Been like hours.
Smart clothes, some smart
He hasn't returned either.
I believe he's on his way, and Bill Hemminghouse said he will not be here. He's attending a funeral. And Jimmy Fox said if he makes it, he will be here very late because he has a speaking engagement this morning. So, but as it currently stands, we have a quorum. I don't know, do I actually officially have to do roll call? Is that a required? Okay. Just me. John Bolts, Jimmy Fox, Bill Hemminghouse, Kirk Smith. Here. Will Rousseau. Here. Ken Frederick. Here. Lynn Evans. Yes. We have a quorum. Again, I just remind everybody, we have all the information put up on the website. We've got the listserv. Please sign up for that. Current status of the Office of Pest Management Department of Ag. The only thing I want to say there is we passed a year. Been over here for a year, and there were several things that were raised as concerns when this whole move occurred, with one of them being the fact that the Department of Agriculture was going to be overwhelmed by this move, and that hasn't occurred. There was also concern about the financial situation of the Office of Pest Management, and I think that has been adequately addressed, and there's timely budgetary things going out to the advisory councils, so everybody knows where the budget's at. And also we have made it through a licensing year, which also people thought we were going to be overwhelmed by that. And I guess what I can say about that is 77% of the licenses were done online this last go around. So that's a real good thing. The Department of Agriculture is working towards allowing our folks the opportunity to do that as well. So I don't think there's anything else that we need to bring up right here. Just wanted to let everybody know that that's going on. Oh yeah, this is this. we need to have, I think we need to have an orange button in front of you. So if you look at your little thing, make sure there's an orange button. Or orange in the little orange, that means it's on. Does that mean it's on? I think orange means it's on.
So you want it black, right?
No, I think
I think you should put that. We're on.
With that, we're going to continue on through the agenda, and since Robert is not here yet, I'm going to jump around on the agenda a little bit. We had set up 3 subcommittees at the last task force meeting, devices and groundwater reporting and the golf courses. And so what we'll do is we'll go directly into devices, and the information came out in the latest packages, and so I guess I'd like to open that up for discussion. Vince, is there any introduction that you'd like to give in regard to this?
Yeah, basically, for the record, I wanted to publicly thank those that actually served on the subcommittee. Mr. Harvey Logan, Mr. Ken Frederick, Mr. Larry Bard. I don't know if Larry's out here. Yes, he is. He likes to sit in the back because he doesn't like attention. And Mr. Brett Cameron. Mr. Bard is an expert with regards to bed bug dogs, so his input was very helpful. So just for the record, I want to publicly thank you folks for actually attending. Also, when we had this committee, or when we formed this committee, there were some things that we wanted to accomplish. The majority of the committee members had a desire to allow the director of agriculture to have the discretion of determining for himself which items would be regulated. And so when we crafted the rule, we took that into consideration. The reason why the rule actually does exempt certain items, though, is because of the concern that we as staff had. We as staff were concerned that if you just allow the director to make this decision by himself, what happens when the director leaves and another director comes forward. We didn't want one director to form an opinion, and then if that director leaves, then another director changes that opinion, because then that's frustrating upon the public as well as the industry. So when we crafted the rule, we actually inserted certain devices that no matter who the director is, these particular items would be exempted. The proposed rule will reflect that language. We were also concerned with regards to the topic of a young boy who seems to come up even though it's been 5 years later. We wanted to create a rule whereby if another young boy or anyone were to use specific devices that really didn't harm the public or the environment, what would our agency do? So we believe that the language that we currently have will allow us to just back off, just leave it alone, and thus protect the reputation and the integrity of the Department of Agriculture. That's all.
Okay. As these packages went out, there were things that were changed and were in the rules. And so this is the statute again, basically describing what a device is. And I don't know if we need to, if anybody's wanting to look at every one of these things in detail or not, but
Kurt?
question? Later. Huh? Go on this?
Oh, on the device then?
Yeah.
Yeah, hang on to that. On page 4, our definition of the device.
Is that of the?
On the statute, sorry.
Go ahead. I'll get there. I'm just going to get this up here first. And then I'll go back.
I thought you were on the statute.
I was already. definition?
Yeah, it's kind of a minor point, but maybe it's more legalese than anything else. I know what the term contrivance means, but a lot of people probably don't.
I had to look it up.
Yeah, I'm just wondering if that's the appropriate word to use, because it has more than just one meaning besides the mechanical instrument.
I think what we did is we were trying to be consistent, again, with what federally is.
I understand that, yeah.
Do you have a suggestion for a better word?
No, it's just,
Well, if you find fault, you gotta give us a suggestion.
I showed this definition to several of my licensed applicators, and nobody knew what the word contrivance was. I'm just saying, should we define it, just get rid of contrivance and just call it an instrument or mechanical device, instead of just using it. I mean, it's a nice looking word, it sounds good and all that.
Well, leave it and define it.
I like it, it's a $5 word.
Jack?
Yes.
Jack, we had this discussion at the subcommittee about contrivance because I brought up the same question. And we decided to leave it because that's what matched all the other definitions of it. And it was more all-encompassing rather than a mechanical device because we were calling the dog a device. And so that's a contrivance.
That's true.
And make sure you introduce yourself.
Oh, that's Larry Bard.
No. Okay. Okay, I mean, thank you. That's kind of explanation. Anything else on that?
So, just for clarification, back on the rules, since you were there, sorry about that, on the device, page 34.
Go ahead.
I'll get there. Section B. So, maybe this is just for the benefit of the folks in the audience here, but what we're saying is if we have a company that does pest control without using registered pesticide, and all they use are devices, they don't need to be licensed through this agency to do that pest control.
These devices.
Correct. That's what
I have a big question mark about this, Ken Frederick. Frankly, because I think it's confusing. And because if you look at the definitions of pest management services and advertisement and such, these things are what you're saying we have to be licensed for. Because they're advertising, if they advertise to do any kind of pest control, according to these definitions, they need to be licensed. Even if they're not using a pesticide.
Now, this
is not
are not subject to licensure. These are the things you can use and not be licensed, correct?
Yes, but I'm saying the way pest management is defined in here, I think is confusing because to me, I think of Mr. Packrat would do something. And he doesn't use any kind of pesticides. He does all trapping and all that kind of stuff and such. But he advertises that as a pest control service. So I think if somebody's going to advertise as doing this for pest control means, even if they're not applying something, either that or something in the definition of pest management needs to change.
But are you agree that this agency shouldn't regulate Mr. Packrat?
I think if he's doing pest control, he should have a business license and a license to do it.
But not an applicator's license, not you can do anything and need a business license. By the way, the best name for somebody like that is up in Pine Top. The guy's name is Critter Kidder.
Which guy makes it the same.
Is it really?
Same guy.
Is it?
Same guy.
Okay.
Chris.
But in section B, we do have that phrase that they have to include not a licensed pest control company in all their advertising.
I understand that.
Now, my question, Jack, though, is we have several companies that do nothing but bird work. So they've got advertising all over their truck. So now we're saying instead of a license number, they're going to have the phrase that they're not a licensed pest control company on that truck. Is that the idea?
In all written and oral advertisements. So anything that's written and anything they orally, they need to make sure they're informing folks that they're not a licensed pest company. So that, we didn't address the trucks, I guess.
It's written. It's written.
A truck, it is
Yeah,
written.
my truck is- oh, yeah, actually,
My truck is my billboard.
No, that's true.
Yeah.
Okay, I wasn't looking at that. So, okay.
I mean, just from my point of view, I have really big concerns about this, but maybe it's just because I'm honest. I don't know.
I like it.
I do too.
I mean, it just, and I know there's, people can disagree with me, but it just, these are things that are, I don't know, that are just common things that people can do, and that just, why would we make them get licensed through us to do those things?
Will Russo, in the aforementioned example of the little boy with the roof rats, this keeps us from getting embroiled in that again. And we can't be accused of trying to hinder capitalism.
You know, and the other thing, I mean, the other side of this, I think when things calm down, you know, and this is going to get much slower even. I think that what, as the regulatory agency, we need to inform the consumer what they should be looking for. I mean, for one thing, as a consumer, you want to make sure that you're hiring somebody who has insurance. And so, you know, if you're hiring somebody to do this, you want to check, do they have insurance? You're not licensed to test, but do they have some kind of insurance? So that will is yet to come. So, whatever.
But doesn't Office of Pest, don't you guys get phone calls lots of times from people wanting recommendations of companies to go to for certain pest control activities? If somebody's got a pigeon problem now, and they want pigeon work done, they're no longer licensed for you. How are you going to handle that?
We call all the time, we recommend no one.
Yeah.
We never provide any recommendations. We regulate.
Look at the yellow pages.
Yeah, it is. I knew you was going to say that.
Me too. So, Harvey?
My only concern.
Harvey, go ahead.
I'm sorry, Harvey, on the Western. That's right. My only concern serving as a committee was, is that there are some devices that are not efficacious. In fact, they're phony. And to the extent possible, and I realize it's very difficult, it would be very difficult, I would like to see the consumer protected when there is a phony device out there advertised for use in pest control. And there are any number of them.
Like the ultrasound.
Pardon?
Like the ultrasound.
That's exactly it.
The consumer already has a path, though, that really, if they wanted to pursue that.
I'm sorry?
The consumer already has a path to do something about that.
I'm not
expensive.
suggesting that it go any further. I guess I'm just
Want to make sure that we can do something
defending
with
what
that.
my concern was.
Right. Okay. Thanks. Go ahead.
Henry Schneider, International Accommodations. I think that Office of Pest Management and Department of Ag have no business regulating devices at all, and there should simply be a statement in statute that says so, in very clear terms, that they are prohibited specifically from regulating devices. They should stick to what they're supposed to regulate, which is pesticides, and stay out of the rest. You know, like I noticed you're trying to regulate birds. Okay, well, you know, I can use a bird on one occasion, but I can't use a bird on another occasion. You know, like, you know.
Or you regulate
We're not
birds in
regulating
that
birds.
state.
Huh?
We're specifically saying not subject to licensure.
Only under a certain set of circumstances. A bird for this particular purpose you're not going to regulate. Well, you know, like it's like trying to say that I can't go out and use a fly swatter in my business to damp down flies. You know, obviously a fly swatter is a device, and if I want to go out and spend my time swatting flies and charge people for it, why should you care? You know, it's certainly not hurting the public. You should stay out of devices and stick with pesticides.
True.
I think there are devices, though, that, at least in my mind, that are of concern. You know, we've talked about the bed bug issues and people going in and heating the buildings up to 120 degrees, and the people who are going in and freezing things. You know, I think the opportunities for not only harm and fraud are real high there. And those are kinds of things that I think we need to keep a finger on.
You can't regulate morality. There's no way that you're ever going to regulate morality. And so...
Okay. Anything else on devices? Having done, we'll go back and we'll do golf courses. Robert, I don't know if there's anything introductory you want to you wanted to say, or
actually, I'd like to thank the subcommittee members who participated. I really appreciate your time and energy. Also, the folks that attended the meeting that weren't part of the subcommittee but did decide to attend and provided input. It's greatly appreciated. I think, or I believe, we came up with something that will work and shouldn't be too much of an issue for institution, and giving the golf course committee what they're looking for, as well as giving the Department of Ag an avenue to regulate without being overburdened.
any questions on this? I know there was, we had a discussion about, we hadn't thought about the commercial guys at first, and then we came to, ultimately, if a person is applying on their golf course, they are a private applicator. If they're doing it for hire, they're going to come in for hire on a golf course, they're going to stay a commercial applicator, and they'll be certified under the Office of Pest Management. So it's just those that are applying on the golf courses where they work or they are employed, where they will be licensed under the Department of Agriculture. So, go ahead.
You might as well bring it up. It's on page 59.
Page 59, thank you.
Just some clarification for me, I guess. We've got three definitions here. So a certified applicator will be allowed to apply pesticides on the golf course.
A golf applicator. What do we, go ahead, please.
Members of the task force, just so that everyone's clear, the definitions listed here are definitions that relate to the Environmental Services Division of the Department of Agriculture and not to OPM.
Okay, because I'm looking at, this was,
Yeah, those pages at the very end.
yeah.
That's
So,
Department of
so now we
Ag.
have a new cat, sort of, okay, I understand that. So golf applicator now is going to be the person that's licensed to apply pesticides.
On a golf course.
And that golf applicator comes under the umbrella of ag and not Office of Pest Management.
Correct.
So they're not going to have to go through, because you go through core examinations and a few other things. So the examination process for a regulated grower, for a golf applicator, is what you're currently using for ag and not for pest management.
We haven't come to the test yet as to what it will be. If there needs to be anything different with that or not.
So my point, there's not going to be a separate category in pest management for golf applicator.
There will not be.
Yet the golf applicator needs to be a certified applicator. That's where I was confused.
If they're applying on their own golf course, if they work or they own, they will be certified under the Department of Agriculture to apply pesticides. If they're doing it for hire, they'll be certified under the Office of Pest Management under the, most likely under the ornamental and turf category.
Okay, that was where I was confused. And then the regulated grower is going to be the designated responsible party.
That's an agriculture.
For each golf course.
Yes.
So a company like Troon, which owns multiple golf courses, won't be allowed to have one regulated grower. They have to have a regulated grower for each course.
No, they couldn't have one for all.
So then it's for a company or corporation, not a specific golf course.
Correct. That's the way it is in agriculture right now. We have guys who may have land in Human and they have it, 60 miles over in Don Valley. How many miles is that?
So I'm still thinking pest management. Who then is responsible for pesticide, for the golf applicator if they screw up on the pesticide application?
In agriculture, it's it could be both. I mean, each case is unique. Like it's, for example, under the work protection standard, an employer is held responsible, but if it's dealing with restricted use product, then the certified applicator is also held responsible. You know, so it depends on the situation.
Okay.
But the applicator will always be on the hook. Okay. Okay. Go ahead.
Under Schneider International Accommodations, I see no benefit in giving the golf courses a whole special section of rule to do things. You know, it seems to me that mostly what you're doing is you're allowing them to escape without QPs. You spent so much time forcing all these other folks to have QPs, and then you let the golf course guys off scot-free. This does not seem like a rational set of regulations. It seems like a bunch of special cases for a small group of people who managed to talk their way out of, you know, a lot of regulation. I think that the golf course guys should be regulated under the same rules that everybody else get regulated under. I see no reason to have a special set of rules just for them.
And I think the reason this whole thing came about is we believe that the application methods that they're using are very similar to agriculture, and so we felt that they would fit under agriculture. So.
Well, I think that most of the pest stuff should be moved under agriculture also, and do away with the duplicity of all these regulations. Everyone should go under one set of regulations.
All right.
And
anything else? I've heard you. Anything else? Go ahead.
More clarification,
okay.
if you don't mind. Golf courses obviously have ponds and lakes typically.
Yes, that's the aquatic.
That's the aquatic part of it. So in order for them to apply a pesticide in that situation, does that come under ag or construction?
It's under ag. It's under that.
It's all under
ag. Yes.
Okay.
If they're going on the golf course, it's all under the ag.
Everything's going to be under Title II.
Yes.
And so every pesticide application from now on a golf course is going to require any to be filed.
If it's on the groundwater protection list, if it's commercially applied, if it's aerially applied, they'll have to report it. Otherwise they will have their own records that they have to keep.
Well, I'm just, because we deal with the vector control of a lot of golf courses breeding mosquitoes, I just want to get comfortable with how we go about getting information to them. So, okay, all right.
Go ahead.
I've got good termite pest control. Have you done a study on the financial impact of revenues that will be moved from OPM to the Department of Ag?
We talked about it. I don't remember the number that we came up with. I mean, do you, Robert? Is that?
We took a look at the number of licensed businesses that have the name, that either use golf course or country club in their name. We came up with roughly, I want to say it was less than 100 that actually had that. However, we do know obviously that there are pest management companies that actually provide services to golf courses. Those will no longer be needed, so there will be a lot more affected. I'm looking at probably, I believe there's probably more than 200 courses in Arizona. Obviously, not all of those are represented under the Office of Pest Management. And then the number of applicators that hold the typical golf course categories, which would be the right-of-way weed control, the turf ornamental category, and the aquatic category. Unfortunately, it's hard to determine which ones are golf course related and which ones are landscape management related because the categories currently are the same. So we have looked at it and kind of looked at the ballpark figure. Granted, there will be an impact. There's no question there will be an impact.
But we'll survive.
Yeah.
Go ahead.
Jack Farmer, representing the Arizona Crop Protection Association. I want to point out that it's my belief that even though golf courses are going to come under agriculture, if they're making an application to a pond, so an aquatic application, they will still need their zippy. But nothing we do here exempts them from getting that.
That's completely different can of worms, yeah.
Fumigation, the same thing. Any soil fumigation, still under ag, even though they're going after.
Yes, that's for the Brewing Road fumigation. Correct. Okay. Henry, did you?
No, I was just adjusting the camera.
Yeah.
One question too, Jack, somebody brought this up, sorry. For, once this transition over to ag occurred, the CEU process that most of the golf courses are used to no longer applies. They're going to get their CEUs through ag-related instruction, not through Office of Pest Management instruction.
Correct.
Or
And you know,
will that cross over for ours?
that's ultimately that's where we're going with them. But you know, we're not there yet. But that's ultimately where we hope to go. People can go to courses that will get them credit for either side of the aisle, because there's a lot of subject matter that will cross over. You know, when you get into specifics of, you know, spraying in houses and doing termite treatments and things like that, that's... Go ahead.
Ron Elkins, City of Phoenix. I was just wondering, with municipal courses, is it still going to fall underneath this, even where we have courses that feed reservoirs that go into residential neighborhoods?
Yeah, it's we have, under agriculture right now, we have like the U.S. Fish and Wildlife Service and things like that that are certified under us, because they're applying on property that they own or manage. And so as long as it meets that private applicator certification definition, it would be at that. Okay. All right. Anything else on the golf courses? Last subcommittee is the groundwater golf course. That was fairly, we put that in there. One of the things that I was going to follow up on, and I suggested I look at a bunch of labels, and I did look at a bunch of labels, and then after I looked at the labels, they aren't even on the product protection list. So there is, based on what I see, and again, the rule basically says if the product's been detected within the last 5 years, they report within a county on a quarterly basis. And what I was looking at a bunch of labels and trying to determine whether it said they had to be irrigated in. And those labels that I did look at, even though they're not on the protection list after I looked at them, they actually said they didn't need to be watered in for 21 or 30 days. So they said they stayed active for that long a time. So unless they were applied directly to the soil, and in turf situations, that's not what they're doing. It would only be in the non-crop or industrial areas where some of those products could potentially come into play. But the products I was looking at didn't, because they weren't on the groundwater protection list. And there was. We looked at basically the DEQ groundwater list. We looked at those that had been detected. We narrowed the list down, and I had David do it for the ones that had been detected in the last 5 years. And this is the listing of materials. And if you look at them, we've got atrazines, and I don't know that that's used in the structural arena at all. We have diuron. That could be used on some industrial sites. We also have, I mean, most of these are agricultural products based on the name of the product, so there's not going to be, my impression is the amount of reporting that's going to be required is small.
Isn't something like diuron used in non-crop areas, and obviously it's used a lot in farming?
Correct.
But I would think it would be used in ornamental or landscaping type applications as well.
Correct. That's correct. And that's diuron and probably the chromatrin and as well.
Jack, how about midclover on that list?
Midclover is on the list.
Well, that could be probably the most heavily reported for pest management.
Yeah, and again, what we came down to though is and again, I should have started off by saying thank you to the committee members for sitting through and coming to a resolution on this. Appreciate it. I didn't. There was a time I didn't think we would work, but we actually did.
I got a question about it.
Go ahead.
First of all, Ken Frederick, again, this was out there. As I told the committee, this reporting thing is not something I appreciate very much. And I'm sure all of you as agri people are not very appreciative of it either, so I understand. However, We're going to have a new category here called the private owners, that you're going to allow them to hire people to do pest control that do not have a business license, including termite work. So they could be using the incorporate on termite work. Are they going to have to report it as well?
The termite work, and you said, Kevin, you said in on this too, the termite work was not under the slab treatment, but when they're coming in and doing the final grade, if they were using the medical.
Yeah, I'm looking in Tucson, and and I don't know about Phoenix. In Tucson, almost all the new construction is post-tension slabs on the long. So you trench the outside. Somebody comes in and trenches a 40-foot wall and applies a new appropriate at 16 gallons. Is that going to need to be reported? If you're a private owner, how are you going to be able to do it? Because according to this new regulation, a private owner can hire somebody and have an employee working for him that doesn't have a business license but has all the other licenses. How are you going to be able to regulate when they're reporting?
Well, as a private owner, they can do that today. I can do that on my own property today. It doesn't change it. I think, are you trying to get at when the private entities, when we're allowing them to treat on their own properties? Is that what you're?
If they own an apartment complex,
Okay, they own the
they
apartment.
want to hire somebody to take care of the pets.
Okay.
That's fine.
But if they wanted to do it themselves, is what you're talking about.
They hired this new category. Qualified
Qualified applicant?
No.
Private owner.
You're talking about private owner.
They still have that.
They still have to have a
They have to have a QP,
So
they have to have a certified
The
applicant.
QP has to do all the record keeping. But do they also have, does that mean this part as well? I just want to be clear.
The only exemption that they get is the business license. They have to abide by everything else.
Because this is going to be forced upon us and everybody.
And it would be. We haven't exempted them out other than the business license.
Just want to make sure.
The only person that would be exempted is if I were putting them in forward on my own.
Sure.
Yeah. That's what I thought.
That's the exemption. And that's, you can't. And that's
Can't
a problem.
regulate that, we all know that.
That's a problem we've had forever. The argument that there's no answer to it.
Good question. Okay, anything else on this?
Yeah.
Go ahead.
Question on a form approved by the department, they would report on a quarterly basis. What are you thinking as far as forms? Are you looking at a 1080 form or something hopefully a lot more
Names and-
simplified?
Introduce yourself to the court.
Oh, sorry, Courtney Levinas, Capital Consulting.
For the like final grade and things like that,
Yeah.
we were thinking we could potentially change the TARP database and just with a slight change and they could do it that way. For the other areas, we thought it more closely related actually to 1080 and go ahead.
Much simplified.
Much simplified, and I talked to our IT guys about that, and basically taking stuff from the 1080 database and putting it into something else that would allow us to do the reporting that's required under this. So very simplified 1080 process, yes.
Another question of the ag folks here. How long have you been reporting this groundwater stuff?
1990s.
Yeah. I mean, the biggest
Clean Water Act.
Yeah. So, the question I have is have the materials or active ingredients added to that list? So that has that list grown?
Yes.
And see, that's the biggest concern.
It grew, but it also has gone down.
Because right now, you need to put in deletions, but
Hold on.
what's going to come next? Because the very first meeting, I sat here and said, I'd love to get rid of this TARP because my fear is one day the TARP is going to mutate into something that requires us to report everything. And I just see this as the beginning. And it already this reporting stuff is going to be pretty burdensome. And I know I'm preaching to the choir to you guys, but somehow.
Other than Will Russo, I mean, no, none of us like regulation or reporting, but at least personally, I'm of the opinion that reporting has been beneficial because then our industry has true hard numbers that we can show what our actual usage is. That helps us with registering these compounds. It also helps us with diffusing the arguments from the folks that would have you not have any pesticides. So in total, yeah, it's a hassle, and yes, it's a administrative pain, but in total, I'm in favor of it.
And, you know, John has mentioned to me before in the past that it's helped in arguments with people, the data has helped.
Well,
It's just the fear, I don't want to be like California where they have to report all kinds of stuff.
John Bolts, one other point to add is that the Department of Ag, at least on the agriculture side of things, has been super painless about it. I mean, we have a form that we're already using, you know, hopefully Jack can work out something where it's something you guys are already doing, very simple to file, and, you know, we shove it in the fax machine and send this form, it goes through, okay. That's kind of last we heard in the Department of Ag here, right?
Or you can do it electronically.
Or, yeah, electronic, so, depending on the software.
I mean, if they set up the TARP system, so it's just a click or whatever, I mean, I don't think the industry's going to cry a whole lot. They will initially.
And they'll have to keep adding materials to that list because of the laws and the way they are and how that's regulated, because in the case of Medi-Cloprid, the Clean Water Act was passed, Medi-Cloprid was a twinkle in a researcher's eye, you know, I mean, it wasn't even there.
It will be an evolving thing, yeah. And I think that the overarching concept of, you know, if we have to report a compound to protect the groundwater, then your industry should, when it's applying the same compound.
And not to be disagreeable with folks, but the list is going to evolve. But I don't think that it's necessarily going to grow. And the reason I say that is because the chemistry has changed so much over the years, and you know, I just don't. The leaching of materials is a concern to the registrants as well, and I think that's. I just don't think that it's.
Become less of an issue.
Yes. So.
Just a comment on top of that, Ken. DEQ also regulates a new program that the feds require, which is the groundwater, the National Pesticide Discharge Elimination Program, where some of us have had to file permits and keep certain on any waters that are any pesticides we find in the waters. And that's just a major thing. There's nothing we can do about it.
Okay. Go ahead.
Henry Schneiker, International Accommodations. I think that the set of regulations for the pesticide industry specifically, ignoring ag for the moment, is basically provides very little gain for the amount of overhead that it imposes on the industry, and I don't see a net benefit that justifies all of the overhead of keeping track of these things and filing them on a regular basis. And just like Ken mentioned, I also worry about it being just another excuse to keep the TARP database around and to expand it over time. A database that I and a lot of other people believe should be completely eliminated.
Thank you. Okay. Now I've got a list of things that we don't necessarily need to go to each one of these pages, but I've got them marked and everything, but I just want to make sure that everybody's keen on these things, and we're not, because we have to get to writing a report, and I want to make sure that nothing is ruffling anybody's feathers. We set the minimum age for certification as 18. And, I know that's probably not a big issue to a lot of people, but nationally, if the new regulations do come out, I'm certain that they're going to have a minimum age of 18 for commercial application. And we've had discussions with some insurance companies and stuff like that, and they said that for insuring underage people in a business, it's a very expensive thing. I'm sure you can get it, it's just going to cost you a lot. So I just want to make sure that it's not crushing anybody with this.
But this doesn't preclude my 16-year-old son having to go out and do a bunch of holes.
He could be a laborer, dig holes, he just can't be certified.
He doesn't like to do that. He's trying to teach him how to school.
Yeah, you're citizen. That last name starts with F. You're good to go.
The next one is a big one, and we've talked about it, but I just want to make sure, in the report, when I'm writing, I guess as I'm thinking about this one, I'm making sure that the task force is still on board with no criminal background investigation requirement.
And the way this is written, I'm not clear what your direction is. So this is stating what we discussed quite a while ago.
Yes.
That we're going to do away with
Yep.
the criminal investigation.
And the reason I put it on the agenda is because the industry has, the meetings I've talked at, they still would like the regulations to show that they have to do a background investigation. And so I wanted to bring that, have this task force, I don't know what your feelings are. Mine is still, we just stay out of it.
Same here.
But that's just my opinion. And I think there's so much liability on the employer, I don't know how they can afford not to.
Yeah. Jack, just a clarification on that. So when a new person applies in the system, they're still going to have to show citizenship or what's the
That's a legal residency.
legal residency. So
That's a separate thing.
That's a separate thing.
Another question, just to be clear. What if somebody's applying for a business license? I mean, today they have to do a background check and all that, if I remember correctly. So you're not going to...
I don't think so.
No.
You don't have, okay, forget it.
Yeah. I mean, that's why it struck me, Ken. I mean, I wasn't, hope I didn't sound dismissive of you. It's just that we've got licenses and all kinds of things. And I don't know the subject of background check. Maybe I should be, but I.
Well, I've been doing background checks on employees for 20
Sure,
years. So
yes. But for us, it's just foreign territory, and really, it's just kind of on a philosophical level. I don't think the state and state agency should be doing that. Frankly, if I were in the business you were in, I'd have that, I'd be doing it. And you're going to be free to continue to do it. You're just not going to be, we're not going to be required.
The concern is, some people believe the state can get a better background check than I can through a service. But I'll be honest, you get what you pay for. If you're willing to pay for a better background check,
Right.
Yeah. That's, I think at the time when we do our background investigation, I think we probably do get as good as it can be. But the problem is it as good as it is at that point in time? And, I hear the thing on the advertisement on the radio all the time. There's a yearly review, and it's all about data, looking at data and finding the stuff. And that's where you keep track of people if you have problem people out there. So.
I found out a driver had a DUI. He never told me, but my insurance company found it.
Okay, supervision of uncertified individuals, and we had some discussion about this, and we set the limit at 2, and we just took it out that for anything, most you could supervise uncertified is 2 people. So that's kind of like these people, and again, what we did is we added in the definition for laborer, because there was a whole discussion about who are these people, and it's not people drilling the holes and digging the trenches, it's the people who actually, I always say it's anybody that's dealing with a pesticide after the container's been opened. So you could supervise up to 2 uncertified applicators, so, okay? Good?
Henry Schneifer, International Accommodations. I've got no objections to laborers doing labor things. But I do have an objection to having uncertified people applying pesticides without a license. If they can take the additional time, spend the extra 90 days, go get their license before they start applying. They can go do ride-throughs and everything else to get familiar with routes, but they should not be actually applying the pesticides for commercial purposes without that license.
Okay. That's a related topic. Okay, thank you. Private owner registration. And I know there was some email traffic on this, and again, the purpose of this was to allow people to fly on their own property. They still have to have the insurance, they still have to have the certified applicant, they still have to have the qualifying party, but they didn't have to have a business license. That's similar to, I guess, government. We're not requiring them to have a business license. I know that there's concerns. I don't know if there's any discussion that we want to have about this, or I'm looking at Ken because he's in the industry, and I'm going to look at the front row there because you guys are in the industry. And I mean, anybody that's in the industry, if this is a
my concern is what's going to happen in the future. Is there a possibility in the future of something bad happening that's going to reflect bad on the agency? Because I don't see it. now that if everybody's gonna be licensed and all that, maybe that affects the department. But, I have a hard time writing, so,
Bob Wagner, Wagner Pest Solutions. The only issue that I seem to have with it was on the bed bug side. I kind of read some more email that went through this morning that said that a landlord would have the right to charge a resident if they deemed that they brought bed bugs into the structure. Now, my company, we probably service 30 to 50 units a day for bed bugs, and every day, every property says that people brought them in. So it'll be a continual thing where they're charging these residents to treat the units. And I kind of feel like if they're charging residents to perform pest control service, they're in the business of pest control. They're in the business of structural pest control, and they should be required to have a business license if they're charging. Thank you.
It's hard not to split.
Yeah, and that,
Okay, I'm gonna go to the task force. That brings up an interesting point. If I own an apartment and I'm paying to have the apartment owner to come in to do a bed bug treatment, and it doesn't work, do I come to you to file a complaint against the owner of the apartment for doing a lousy job?
Sure you would.
So
If you think something was done improperly, yes.
As long as he's licensed as a private.
Yeah. If you registered.
Well, you have to be licensed as a private owner to be legally making that application.
Yeah.
You just have to be qualified. You have to have a qualified applicator.
Yes, you have to have a qualified applicator, you have to be a certified applicator, you just don't have to have a business license.
But Paul has a point. If he's gonna be making income off of treating for bed bugs, extra income over the rent.
True.
Do we need to?
I have to be licensed to do that.
Sorry. No. I'm just wondering, do we need to tweak the joint responsibilities laws to include private owners?
I don't know, I guess I don't, in my mind, private owners are gonna be on the hook just like everybody does. And we're exempting them from business license.
Because right now, it's the business that keep you at the apples.
So, I think we've got fairly strong joint liability language written in that, we're trying to hook everybody up, so people can't go, oh, same, it's similar like we have in agriculture, it's a strong joint liability. I think we're probably there. I don't think we need to change anything, because that the exemption for the private owner is not they've not exempted out from anything else.
our point goes back to Bob, that if we can put a provision in it that says that they just can't do it for hire, they can't do it for profit, that it's part of the business or the service they provide, and they're not charging above and beyond the rent, or whatever charges they charge. Just like we couldn't do it on a contractor basis, when they have maintenance people that go in and fix things, that they can't go in and fix something in the unit for hire, or they have to be a licensed contractor.
And yet we're hearing anecdotal stories about people charging
Yeah.
for it, and I don't know whether that's the case or not.
Well, I think right now, because they have to be, they can't do it for hire. Right now, the apartment communities, property managers have to hire a licensed company to come in and do it. So they do charge the resident if the resident is at fault. But under this, they're saying that the apartment community can be a private owner and then supplement their income by treating those units for hire. So I think if there was just some language that is, as long as it's not for hire or for profit.
Go ahead.
Members of the task force, I believe the policy decision that was you on this, but as far as supplementing the income, my understanding is from a landlord perspective, they're charging back the tenant. They're not charging the tenant for a profit, or at least that would be proper. They would be charging for their actual cost. So they'd be covering their cost, they charge back the tenant. And I'm speaking just about general law here, not about OPM specifically, but for any sort of damages that the tenant did to an apartment, whether it's bug related or not, the landlord would be recovering their cost. So if the landlord hired a third-party company, that third-party company would include their profit, so that's part of the landlord's cost passed back to the tenant. But if the landlord's doing it himself, the landlord can upcharge extension that would be improper. So
And I
it's just great information.
That's what I think you guys are saying, is they upcharge. They can upcharge, and then they're making them.
If I can make a, because I do so much multi-housing bottle wire test, the only time I see charges made currently is if a resident refuses to cooperate, or refuses to get ready for the services, and they do that through a lease addendum. The most common one I see is Scott Clark's lease addendum that's going around, but my question to what the gentleman at the table just said was, how are you going to regulate that? How are you going to regulate those costs?
Again, I guess
Excuse me, a friend of mine moved into a new apartment, has bed bugs. In the lease that he signed, it says that the apartment was inspected and certified bed bug free before he signed the lease. So they're assuming he brought the bed bug with him, and they charged him $1,100 for his bed bug. So if a property manager has that in the lease, I mean, I don't know. I just don't see how you can justify somebody charging somebody $500 to do additional work for bed bugs, and not have a business license.
I think the problem I'm seeing is the potential that we may be putting a tenant at the mercy of a landlord. Because if I can treat, I can charge, whereas now they potentially could say, well, no, I'll hire somebody to come in and do this. Whereas if we do this, and they could be at the mercy somewhat of a landlord then. That I don't like. I mean, does that make sense?
Well, I know Frank couldn't hire me to treat his bed bugs because the apartment complex had a contract with another company.
Yeah, well, but it was a third party. It wasn't like, I mean, it wasn't just me jacking it to him. So. Go ahead.
Jack, Larry Barton knows. I believe the Landlord-Tenant Act, as modified by the state legislature last year, ARS 33-1319, indicates that owners are required to do an inspection within 7 days of a reporting of an infestation, and then if it's confirmed by a licensed pest control operator, they have another 7 days to then treat that. I don't think the court has decided who is liable for the treatment, that they can recharge it to the tenant. It's the owner's responsibility, from my understanding.
Yeah, I can actually address that, because I think what you're referring to.
You are?
Courtney Levinas with Capital Consulting, was a previous version of the bill that passed in the 2011 session. And so I think that was originally in a draft version. It was not the version that was passed and signed by the governor. So there's no requirements on the landlord of response time or any of that. The only requirements on the landlord is that they can't rent an infested unit, and that they have to provide education material to all new residents about bed bugs.
It doesn't also say something about the tenant has to cooperate and the landlord has to deal with it? I thought
that was in previous versions of the bill, and then the bill was substantially amended in the House. And there's basically just 2 provisions for the landlord, 2 provisions for the tenant, and a lot of that language was struck. So.
Jack, the whole reason we're talking about this is to allow a property owner with the proper training and licensure to be able to make his own application. The only thing he's saving is a business license. So if you assume that the property owner is complying, where's the additional exposure to the public or the environment?
Again, and maybe it's a far-fetched, it's just that, you are at the mercy of the landlord, I agree, but if and I can be in cahoots with the guy who can have come in and spray as well, but I'm just thinking, at least with the outside party coming in, I can't just say it's going to cost you $500 every time they come in here. Every time I come in here and treat, it's going to cost you $500.
Again, I would think that if that were a situation,
you'd move.
Unless everyone does it, and
And-
Collusion on a large scale is virtually impossible.
Yeah.
I know, I'm in the produce business.
So again, I think what do people have a problem with what Courtney said with not for hire? I don't know how we're going to regulate that. I just don't. The landlord, we're never going to get in the middle of that tenant whatever unless somebody complains. And I guess that's when we get called in.
And is it our position or the department's position to get involved in and to adjudicate the situation that Ken just described? My opinion would be no.
How do you do that?
That's a, no pun intended, a can of worms that I think we don't want to get involved in.
Ball wagging right best solution, I think the way to get around it is making a business license. If they're making money doing our job, the business of pest control, then they're in business. So maybe get a business license. I think that's all that I was kind of driving at.
You're eliminating this private registration.
Right.
This I'll tell you from a personal standpoint, this isn't a make or break deal for me. This is one of those things that I was just I was hearing people say, it's our own property and so on.
Well, it's not for me either. So I go to yourself. It's not for me either, but it is. I've heard, the underlying argument has been presented at this. In fact, I think it's been presented at every one of our meetings. So that's frankly why I'm somewhat sympathetic to it, is to just make sure that the public understands we are listening to it. And so,
anybody out there want to speak in favor of keeping it?
Well, I can tell you, I wear two hats on this issue. Sorry, Courtney Lyons with Capital Consulting, because I also represent the Arizona Multi-Housing Association. And we have discussed this in our government affairs meetings. And I can tell you, our industry does not have any interest in doing this because they don't want the liability that goes along with it. So the owners that I talk to say, we're going to keep the status quo. We're going to continue to hire out and contract for pest management services because we don't want that insurance premium, we don't want that liability. So for our guys, it's not an issue, and we represent 200,000 plus units throughout the state.
Okay. All right. Well, I'm taking this as a strong indication that perhaps that section isn't needed. And I'll talk to Casey because Casey, and let me say here, at this juncture, I just want to thank Casey for the work he's done in this. I've dealt with trying to, through our rules, doing all this stuff and revising, and it's a headache. And Casey has just been whipping this stuff out. So Casey, I just publicly want to thank you for that. It's awesome. I'm so glad you're helping us out on this. But he's got to make all the changes. So we'll talk to you. Okay. Next we have qualifying party. Political subdivisions, including the state agencies requiring a qualifying party. Kirk, we've had the discussion before, and that there was concern: what is it a qualifying party? Is it a business license? And I think that the biggest discussion previously was that we were requiring all the state agencies to get a business license, and it didn't fit. They're not in business, but I'm open to disagreement or.
I've talked to a lot of my constituents that are in political subdivisions, and everybody seems to be okay with it. The only concern is school districts.
Okay.
And it requires the school district to have to keep the contract. So some contracts, some boards have been turned over this year.
Doesn't it say in there they're allowed to have this type of contracts? If they want to get their agency to have this contract?
But we ran into that situation when this was approached back during the days of the Construction Pest Commission. If I remember right, there were 3 or 4 school districts that are getting ready to file a lawsuit against the state over that issue. So just kind of heads up.
Okay.
is it a common practice that a school district would be doing their own pesticide applications?
Some do, depending on the size of the district and the budget.
And I would think that if it was a large school district with lots of schools, it would be economically advantageous for them to get a QP, get the training, get the equipment, and make those applications, as opposed to hiring an outside applicator. And so preclude our school districts from being able to be economically competitive. I don't think we should, but I also don't like the idea of the school district being able to make their own application with millage percentage.
Exactly.
That's really a bad situation. So
I think the biggest abuse I've ever seen from school districts that we deal with them a lot is herbicide applications.
Really?
They'll fill up a 250-gallon container of pesticide X, and I've seen people wearing t-shirts, shorts, and Birkenstocks go out there and spray the field, and the kids go right on top of it and start playing baseball. You see it all.
yeah, what kind of you turn down?
Gentleman in the purple shirt?
Yeah, Tony Scarpa, Phoenix Union High School District.
Okay.
I think there should be some oversight. I've had the qualifying party for 20-something years for Phoenix Union, and I think they do need that level of oversight.
Okay, good to hear. Okay. And I would think Phoenix Union would be a good example of a very large school district that's going to do a lot of their own work, and it's going to be economically advantageous. So.
And I believe so.
Yeah, he said Phoenix Union School District, you said?
Phoenix Union High School District.
How many schools would you say?
We've got 18 sites, 11 comprehensive high schools and 4 smaller ones, and then administrative centers.
Okay. Thank you, appreciate it.
Going back to what Will had said earlier about the SPCC days, the legislature has said multiple times that they did not want a requirement for QPs placed upon the governmental entities. And in fact, during the Sunset Review, Barbara Leff made a very direct comment and said, like, we told you not to do this and you went and did it anyway. Yet another reason to, sunset you guys. So I think it is, that even staff has said in these meetings that, look, the legislature has trusted the political entities to do their own pest control without QPs for all these years, and there have not been any major problems. And so there's no well-founded reason to require them to suddenly have them now. It's not that you're trying to fix a problem, except for from the standpoint of the other people who are trying desperately to justify QPs as a barrier to entry. So there's no good justification for the political subdivisions to be forced into having QPs.
Thank you. Go ahead.
Ron Elkins, City of Phoenix. I think this is a very good move. I really do. Okay. And I strongly disagree with you. There's things. So this is a very good move.
Thank you. Appreciate that. Again, I just put out here again, we made the decision as to what the requirements are. And, you see the tiers, how people can go through. If you're licensed in Category 1, you can broaden into, I think it's 2 and 4 and 5 or whatever they are. I just don't remember. It's into the right-of-way and in the turf and ornamental category if you have a general pest control. And if you have the wood-destroying organism, you can broaden into the turf and ornamental and the right-of-way. And the only reason I keep bringing this up is I still have, this is just eats at me. Is as a business owner, I go in and I become a business owner, and I've run my business for 15 years, and now I want to go into another category. There's no way to get there unless I go and work for somebody else. And I know you have to understand how to make applications, how to do these specific things, but do we have it right? I'll just put it out there, and it's the last time I'll do it. I know we want to maintain a professionalism and we want to make sure these people are doing things right to protect the public, but are we there?
Could you summarize for me what the current suggested requirements are, please?
From Rule 211,
I'll turn to that.
Is it rule case?
Yes, Rule 211. Page 28 of the rules.
think it's at the bottom. Right there, and D, put it up the top of the screen.
This is broad.
So,
This is the brain section.
right now, it's 2 years of licensure.
So you're just discussing broad.
Yes, 2 years of licensure to come in and get a category initially.
Do you want to talk about the original one or no?
I'm okay with that too. I think this group, we had set up some different, initially we had set up different timeframes, and this group says that gets to be too confusing, so let's just put them all the same. And so we went to 2 years, but I'm okay with the discussion on that.
Just for qualifying applicant.
Yep, and that's what I'm talking about.
You're not talking about qualifying parties.
Well, remember, it's qualifying applicator when you qualify business to become a qualifying party.
So what are you suggesting, Jack? You eliminate the experience and just go cash test?
No, I don't. I'm not there because I think it's important that they have experience because we're sending people into hospitals, we're sending people into your homes, we're sending people into schools. I mean, there needs to be a certain level of knowledge in these folks. And I don't know that you can necessarily test that. And again, you know, I use my life examples. I worked for a plumber for several years, and they got a guy who came out of Votech, who had gone to school to become a licensed, he was going to become a freshman plumber, and then coming out of school, he didn't know anything. You know, and so I think that the experience, you need to have some basis of experience in these things.
And I don't disagree with you about some level of experience, but as I look back at this, 2 years seems like an awfully long time.
Yeah.
To me. And that's been one of, there's several kind of lightning rod issues. This obviously is one of them. I agree with the decision to maintain the framework, if you will, of a QP. But I think you ought to have an earnest dialogue about lowering the requirements. I would tend to agree with you that some experience, in addition to educational accomplishments and passing a test, I think those are all important, but I think some experience is good. I just don't know that it needs to be 2 years. And honestly, I'm afraid that sounds like a long time, and I'm afraid that we're going to be potentially guilty of the barrier to entry assertion that's been made.
Yeah, and that's, I'm just going to, my concern is also going to the legislature. We don't control that process. They're going to make that decision. And if we can't get people to stand up and fight for what we put forward, they're going to decide what they want to do. And so, and I'm not saying 2 years, we can agree that 2 years is the right one. I guess I just, you know, I've gone to the meetings and the industry members there they think 2 years is a good length of time. And they're the ones that this will affect. You know, we've gotten emails saying that it's too much and everything.
And I don't want to fall into the trap of listening to, you know, the local opposition completely. And I do think it's important to listen to both sides of that argument. So I'm not saying that we should cave into it, and I'm not saying that this was arrived at in less than a studied fashion. I just, as I read it, and you just said the word I was looking for, which is the word that this is going to be the last time we talk about this. And I just would wholeheartedly support that. But in light of that, I just feel like they're a little too stringent. That's my thoughts. I'd love to hear what the rest of the task force has to say.
And you know, I'll disagree, but I've been in the industry for 32 years and such. When I first got into the industry, it was 24 months to be able to get your qualifying party and your business license, and then it switched to 2000. And we all know the history. But when I did some research with the states all the way around Arizona and the Southwest, New Mexico requires only 1 year's experience to be able to get a business license, but all the other states around us are 24 months. California is 48 months to be qualified for a termite license, which I find interesting. But, and I'll be frank, I don't like the term barrier to entry. I think it's a fallacy. I asked Robert earlier today if he could, I don't know if you looked it up.
I have it.
In the last 24 months, how many new businesses in the pest control industry?
In the last 24 months, 224 new business licenses were issued. That's actually, I think, a little less than the qualifying party licenses that might have been issued.
For new pest
For new
control.
pest control businesses in the last 24 months. And we all know we're in a slow economy.
Right.
So the barrier to entry thing, it offends me, to be quite honest, because realistically, we got 225 new business licenses in 2 years. How many industries have done that in the last 2 years? You know, it's not that expensive to get in this industry right now. You need 24 months experience. Right now, the tests are not very difficult. To be quite honest, they're pretty simple, and those need to be improved. So a barrier to entry, I think, is a fallacy. I know there's some people that say that, but realistically, I think the expectations are not that long.
To me, this hinges on the difficulty of the test, which is a little hard to substantiate. If this can indicate that the test is simple, then the experience requirement to me needs to be higher. But if the test is substantially more difficult, and it would be difficult to pass without experience, then I think you can lower the experience criteria. And I understand that's hard to measure initially, but if we're talking about making the examinations much more difficult.
I'm correctly, I'm sorry, this wasn't in the passing rate like 68%?
On your current test?
Yeah.
75.
75?
75 was for 1 month.
That's the passing rate, but I'm talking about the...
60 in the 60s.
I thought it was 60-some% was the overall passing rate for the first attempt.
The average percent pass rate now is, for the current month, was 74.3%. Fiscal year to date was 66.1.
Is that first time?
It doesn't actually break it out that way, but it says the attempts to pass is actually 1.5 is the average.
Jack, I kind of agree with you on this thing because let's say I'm doing the general pest control business, I'm real busy, and I want to expand and turn on the mouth. How do I go about getting that 2 years of experience? Most people, do you hire a QP to work for your company?
Well, we're just talking initially.
Yeah, I'm just talking about expanding your business into other areas as well, because to me that's a major hurdle. Or do you get that?
We've addressed turf and ornamental and right away. If you're in the B1 or the category 1, you know, if you're the general pest, you could expand into those 2 categories. Well, if you're in the wood destroying organism, you could expand into those categories.
But that's not my point. My point is, how do you expand your business into other categories? Where do you go to get that experience, that actual on-the-job experience that we're requiring these people to do? You know, when I graduated from graduate school, I spent a lot of time being book smart. Getting out in the real world like you as a plumber is a whole different thing. Yeah, I can help write an exam because I help write these exams and make it extremely difficult to pass, but it's still not going to tell you that person really knows what it's going to be like to get out and actually do the pest control itself. Because you've got multiple facets of I think to play into the whole thing. But I'm just saying here, most people, if you're going to expand, you've got to get involved with a QP somewhere to go out and get that experience, correct? So either you work for another company or you hire a QP and have them work for you so you can go out and do it. Is that fair? Is that the right way to do it? I don't know the answer.
That's been the past.
Yeah. So, see, that's where, you know, in my mind, You know, and I don't know what the magic number is. You know, I'm in the business for 5 years. You know, can I somehow test into this other category somehow? It's almost like in my mind, I'm thinking once you're a QP, it gives you some gray hairs. You know, you get the gray hairs, you know how the business and all that kind of stuff, but it's different. So we've had several people who want to speak here. Anybody else here? Okay, go ahead.
I think Kurt hit on that.
Okay, all right. And there was somebody in the back here, I think?
Yeah, I'm not going to say that.
Okay.
Too shy.
And again, you know, Ken's right, all the states around us, people are in the same ballpark that we are. I mean, so we're not out of the ordinary. Do we have somebody who wanted? I'm sorry, did I miss somebody?
Yeah.
Go ahead.
So new QPs, it's 2 years if you want to apply. It's a 2-year period.
Correct, 2 years
Okay.
as an application.
So if you're already a QP, I think you should, you should get the benefits since you already have the base knowledge of the industry, that maybe you reduce the requirement to 1 year, 6 months.
Oh, yeah. That was,
Now you're gonna.
you're Tony Scarpo with Phoenix
Yes, Tony
Union High
Scarpa
School?
with Phoenix Union.
Again, okay, go ahead.
Got an average contractors for my capacity control. I think 24 months is fine. I don't think it's a barrier of entry. I think it is an apprenticeship leading to professionalism.
Okay, the gentleman on the way back.
Chris Gillis of Terminex. I hold the QP for Terminex, and we would like to expand into turf and ornamental. I don't have time to go out and get 2 years of experience. So how do I expand my business? Now, as a QP, am I going to jump into turf and ornamental without learning the business? No, because I'm going to protect myself and I'm going to protect my company. But how do we get that experience?
So the rules we have now would allow you to do that.
Yes.
So that you like that.
Yes, I do like that. Because again, I'm going to protect my QP because I can't afford not to be unemployed. Nor can I afford to take a pay, cut a pay if I don't have my QP. So yes, I do like it.
Okay.
I'd just like you to reiterate, you're saying that if you have the B1, you can go into turf and ornamental. Under what conditions? You can just expand your license into that? Is that what we're saying?
Yes.
No, then that eliminates a lot of the problem, I would think. My other observation I wanted to make was that we're currently allowing applicator to work in the field for 90 days without a license. Maybe 90 days is a good number to use for somebody that wants to expand their QP if he has 90 days experience. We're letting an applicator to do that. The QP has already been in the business, he already has a business license, he already has the background of everything that you need. Just an observation. I don't have a dog in this fight, so I don't really care.
And Larry, you're with?
I'm nose.
Again, please introduce yourself when you speak. So,
sorry.
Henry Schneider, International Accommodations. Since a few states that are around us having QPs has been brought up, I should also point out that if you expand your view of the United States to include a whole lot more states, there are a whole lot of states out there that have absolutely no concept of a QP. And so, just because a couple of states around Arizona and Arizona itself happens to have a QP doesn't mean that even 50% of the other states have QPs, which they don't. So I think that should be considered.
I think we also need to consider the fact that much of the United States doesn't have pest pressures like we do what happens in the southern part of the United States. And that's a big difference as well. Go ahead.
Just a quick comment.
And you are?
Courtney Levine with Capital Consulting. We think that the proposal on the table, the 24 months, the ability to broaden, is great. It is deregulating to a certain extent the industry. It is reducing barriers to entry. We would not want to see it reduced anymore unless we have a couple years at this level. Let's see how this goes for a couple of years. If we do, in fact, see that there's a barrier to entry or there's statistical information and data that backs up that there's a barrier to entry, this can always be addressed. We can always deregulate further. We would hate to see it be deregulated too much and then have to come back and under pressure from the legislature if something goes wrong and then overcorrect. So, baby steps.
Okay, appreciate that. Ken said something, I guess, that it also reminds me of we've talked about education as well with this, and it's New Mexico, I think they'll give some credit for a degree, and
We've done that too, under your proposed.
Did we get that for a year?
A year.
Oh, okay, so we get
With a
that
year
credit for a year of
with education.
experience.
Yeah.
Okay, okay,
But you've got to have certain qualified classes in order to do that.
okay. Okay, I think we've come to the same point. I just wanted to make sure that I won't bring it up again. I want to make sure I won't bring it up again.
Well, I thought we had a discussion. I mean,
Yeah.
I'm still a little bit on the fence, but
Yeah.
Will Russo, according to your point, if it were lowered today, it could also be raised back up through the rule breaking process if it proved to be too easy. But
I'd rather make it easier later than harder later.
Okay.
I mean, just from the standpoint of, it's hard, it's easier to do it that way. So.
Okay.
Go ahead.
My name is Stanley John from Desert Weed Control. Excuse me, I've got allergies, but I come to this in a unique situation. I've been in this 4 years. I inherited it from a friend who passed on. I helped him with it, and I eventually ended up with business. And the issue, I don't know what you guys know, I've been here for 8-10 years, but I looked through it as I saw that you needed 48 hours worth of college credits and all of the requirements for spray people, which is in section C. I don't know which one that is, but anyway. And then for the QP license. It seemed excessive to me, and if you want one of those guys, I've fired 2 in the last 2 months. So, but the people with the experience that are out there, and I have QPs. I'm not hurting for QPs, but it seems like a barrier to me when you're looking at having to go back and get 48, taking someone and putting them in a spray truck for so many hours. 3 years, 3 to 5 in the last 3 to 5 years, you got to put in 3,000 hours. And you've got somebody that you want to make a QP, and if he's intelligent enough to do that, he's not going to sit in a spray truck for 3 years. So we've got some stuff that I feel like's upside down. And again, I apologize, but I own 6 other businesses, and I own this one, and this is one of the things that just kind of stuck out as a sore thumb to me.
So can I ask a question of you, just because you're in that unique position?
Certainly.
What we're proposing right now is 2 years of licensure as an applicator. I mean, it makes it black and white. Do you think that helps versus the 3,000 hours of having come in, having somebody document and everything like that?
I believe it's something in a progressive nature that is designed for people that, like he said here about, he's not going to go out and work for somebody for 2 years to get that. I don't have the answer. I don't think that what you've got is an answer that satisfies. I know people in the business who have young sons that are coming up, and they want to go into it. Not me, but some other people, and they're looking at having to send them to college and do a lot of things that these kids are already really spraying right now. I mean, they're qualified to do.
Okay.
So you're eliminating a certain phase. I'd be happy to sit down with somebody and go one-on-one.
Okay, thank you, I appreciate it. Home inspectors.
What you want with me?
There was.
Is there anybody for? He's going to ask.
No, I'd like to speak to that word.
Home inspectors, we went through that, and Robert spoke with the Board of Technical Registration, and basically it came down that those guys are not supposed to be doing home inspections, and so we put it in the law. Basically says if they're going to be doing WDIIRs, or if they're going to be doing a proposal, they're going to be licensed by us. If they're going to come in and they're going to say, oh, you've got some sort of damage here, they can do that. They go out and that's what they're inspecting houses for. We got water leaking here, you got this here. They're not going to be going and saying, oh, you got termite and this is what you should do for that. They're going to say you have damage here. Yeah, and so we're just making, yeah, so, and we're going to keep it that way, so that's that. Advertisements, and this has to do with the guys who are using the devices.
Yeah, we talked about
that. Okay, so, okay, that's the topics that I have. Next on the agenda is actually the report And I'm just going, go ahead.
Before you get on the report, a couple of comments on what you handed out, if I may.
Sure.
In the rules, there's several references to right-of-way, and yet right-of-way is never defined. If you look at the definition of right-of-way, it could mean a whole bunch of different things. You can talk about trails, you can talk about driveways, railroads, highways, roads. Should we do a definition of right-of-way in the rules?
I guess I haven't thought about it, but I guess, I know that in the federal stuff, when you're looking at that, there is a definition.
Yes, there is.
That goes along with that, so we'll look and make sure we clarify that.
Okay. And I have one other point, before jumping into the report, sorry. This get too long. It always gets too long. Oh, yeah. This is a small point, but we've run into this recently. This has to do with continuing education approvals.
Yeah.
This is on page 31, section C. I was at another meeting where they were doing CEUs where all they had was a sign-in sheet.
Yes.
And we noticed several people left halfway through the program, so there was no sign-out sheet. I'd like to see that basic requirement where they sign in and a sign-out sheet verifying these people actually tend to fill out as required. Happens a lot.
Yeah, I agree. I've been on some of those. Okay.
I don't disagree with that. I think that's all I did.
Okay.
Oh, sorry. Page 43, qualifying party management. Section A. We talk about this physically being present at the primary office every 14 days. And then we're going to visit the branch office at least every 120 days. We've changed the time frame to that, but to me, we've still left that loophole open where somebody could go to a branch office on day 120, spend the night,
Go the next day.
go the
but then
next
they have to
day,
be back
and then
for
we're good for
another.
another 120 days.
Right.
Pretty smart. That seems to defeat, that just seems to defeat the purpose of what they need to do, you know what I'm saying?
The greatest distance between the 120 days.
Yeah. And do you want to spell out 120 days or is quarterly? I don't know how to get around it. We're trying to get them to actually be there, you know what I'm saying, on a quarterly basis, actually do
I think we used to have every 3 months we changed that because
Yes.
then people do exactly what you said, but at least with 120 days, they're going to be there at least every 120 days.
Right.
They can do that overnight, but then it's going to be 120 days they're going to have to be back.
Yeah. So all we've done is extended it from 90 to 120 days.
No, there was no requirement before.
There's never a requirement.
I thought it was a month.
No. QB had to be at the main office once every 30 days.
Okay, thank you. That's all I'm done.
Okay. There's several, go ahead.
I just found a couple of things I wanted to get clarified in here.
Okay.
On page 39, just real quick, has to do with retreatments and such, and I might ask Mr. Etheridge over there for some help on this, because I know he does pre-treats here, but in number 8, it says in the last line that is advised that a new construction treatment area is disturbed. The business licensee shall ensure that the disturbed area has been retreated. Shall ensure bothers me.
It's existing language.
Yeah, that's what it is. I know. But I don't know how, if we don't know, if they don't call us to treat that, how can we ensure that it was?
Well, it's only,
Maybe I missed something.
It says here,
if you're
Okay,
advised.
you're advised.
That's what I heard.
Thank you.
Okay.
You get reading this stuff every day.
Okay.
In C, it says, the business licensee shall retreat the structure free of charge. And later on in the rule, it says after the third occurrence, like it always has. And I didn't know if that was confusing. And maybe I'm wrong, because existing language. Do you worry about that at all, Kevin? You're a preacher guy.
Yeah, not much.
Well, I still got my truck for sale after 2 years. I want to buy it.
Let me just throw this out to you. You go out on a warranty call and the property was treated with acne. And when you say free of charge, would it disallow the treatment company from asking the homeowner if they wanted to upgrade the material on a subsequent treatment?
We don't have anything that says you can't.
Free of charge, so you then may be charging for that service.
Vince, have we ever had that complaint where somebody's come in and said, well, I had it treated with whatever you said, and then they charged me because I said I could take product Y instead? No.
Okay.
As long as you're being honest about it.
Yeah. Okay, we'll do that all the time. Go ahead.
Henry Steicher International Accommodations. I forget exactly when it was. I believe it involved Northwest, if I remember correctly. A lady by the name of Laus. Apparently there were, if I remember correctly, somewhere between 12 and 24 callbacks within the warranty period, and she was charged for many of those treatments. The termite company disavowed any knowledge of the current language in the regulations, and I believe they more or less got away with only their hand slap. But she had to do major reconstruction on a brand new building to fix all the termite damage. So
you think this is important?
Well, I don't think it is enforced.
What's happened in the past, Henry, I can't address. I can only tell you if somebody brings it to our attention, we'll do our regulatory due diligence. Okay? Go ahead.
I'm already at Western Service, providing notice to consumers. I don't know if this has any bearing about being mentioned, but I have spoken with you with regards to electronic.
Yes.
And I don't know if that should be included, not included. It's not precluded.
That's a good suggestion. Actually, I like that. And the other thing is, we had we've been notified about the EPA registration number. I don't care if the EPA registration number is on there or not. It doesn't drive people up a wall. And I look at Vince. So
I'd actually recommend that if that's the case that you remove it if it's not a restricted use pesticide.
Yeah. Okay. But I like adding something in there about the electronic. I really do, because then it's covered. Everybody knows that they can do it. Okay. If they follow the procedures. Sure. Okay.
That's a good idea. We do that a lot. I never thought of that.
Okay.
Jim Kruger, Oregon. Back to the proposed QP language, when you visit every 120 days, is there a minimum time frame on that visit? Is there anything?
Same zip code?
Going to get a drink of water, right? They only have to be there as long as they have to do what they need to be as the QP. And do your job.
Okay.
Kurt, under your rules on the penalties, we talked about the director shall assess a civil penalty for each violation based on total point value. Are you going to include in this rule package your new matrix system for that?
Yes.
Cool. Okay.
Okay. Hearing nothing else, I guess with the reports, is there? I guess I kind of want to get your feel for as to what I'm looking at it from the standpoint. Give some sort of background. Give what we all did. Who the advisory or the task force members are. Kind of to get a feel for what we are, and then just start going through and explaining what we've done. And in my mind, I'm thinking, we talked about what are the lightning rods and how we came to our conclusions as to what the recommendations are that we have. And again, part of that has to be, if you look under 8 below, we've got to talk about, the laws and regulations and organizational configurations, funding and everything like that. And I think funding has been, the funding is addressed through the package as how we change the rules and all that kind of stuff. Is there anything specific that people want to, I'm sorry, your hand was hidden. Anything that, I'm going to go let these guys, is there anything that you want to throw out before Joe gets a chance to talk? Okay?
Would you like each of us to submit a bio to you? That you just include?
Sure. That actually, yeah, that would be nice.
Like a little one paragraph.
Yes, exactly. I was going to say one paragraph bio would be great. You know, and when you guys applied, you know, I kept most of that stuff, and it's got, you know, kind of years of experience. But it would be nice to get something from you guys as what you'd like to be portrayed. So, okay. With that, Joe,
Joe Say with Deers on the Farm Bureau.
Okay.
And a little indulgence here, because my comments will be just a little bit long-winded. But I'll try to move quickly. What I have to say is a strategy kind of a thing, and it does speak to this particular point. And I'm not speaking for a vacuum. Lots of conversations, and there's something I want to put out on the table because I think it's important. You know, I think we all agree. And by the way, anything I say, if anyone interprets it as negative, they are wrong. Okay, because I'm very complimentary of the department, the process, and task force. So, and I think, you know, it's interesting through all of this. I really haven't heard anything, and I've read everything that circulates. I do. That I've heard nothing to say that this marriage between ADA and OPM should not occur. I mean, you know, we're there. The devil's always in the details of regulation. Regulation limits business automatically, but regulation shouldn't exist to limit business. And the devil's always in the details. It's a fine point. But backing up, you know, I'm a lobbyist. Looking at this as a legislative package, consensus is important. If there is not consensus in the package that goes across the street, it's legal. It'll get killed. A rewrite of this nature is complex, an omnibus bill. Even if there is consensus, you know, and we're all singing Kumbaya walking across the street, it's still very difficult to get that kind of a process through. It can unravel quickly. We're going to have a brand new legislature. So a lot of those things combine as I think about, you know, getting this package through over there to the finish line. I'm going to recommend baby steps, which the phrase was used in conjunction with something else, but I'll borrow from Portland. I think that the report should focus, first of all, you have to compliment the legislature on their wisdom of putting this process together. You know, I think that's extremely important that we do that because, and this task force will validate that wisdom. And number two, I think the report needs to focus on the fact that this marriage should occur. Let's make it permanent. Let's do it. Let's get on with it. The report should focus on the efficiency, the administrative efficiency, the licensing, all of that stuff, and the reforms. And there have been reforms made. And there will be more reforms made. But, again, we don't have consensus on all of this. And for that reason, I see what's going to happen would be post to this task force will be a series of stakeholder meetings, discussion of regulation, how much you regulate and don't goes on. So, you know, I know this place over there. There are some people in this room that know that place over there. They know what it takes. I believe, and my strategic recommendation is that you go over there and you tell them all the things that have been done, the things that have yet to be accomplished. But the major point of this next session is to get them to affirm, yeah, this is a good idea. It's going to stay permanently in the Department of Agriculture, but we're going to keep it in Title 32 for a while. To attempt a rewrite of Title 3 with all of this, I will predict will be a mistake over there, given, and I'm not saying that the task force can't achieve consensus, but in terms of the stakeholders and all those things,
So my specific recommendation to the task force and is for us, you describe those things that need to be done, but we do not practically or strategically attempt in this next session to put all 32 into Title III. That's my strategic recommendation.
Go ahead. Jack Robert Schuler, representing Western Road Association and Maritime Fire Protection Association. We would also agree with that approach, that it makes sense to take small steps as we proceed, and that if we do those small steps properly, then what we can do is ensure that the OPM folks are here permanently, but that initially we keep them in two separate statutes so that we can avoid confusion, if you will, across the street. I would agree with what the position of farmers is.
Okay. Oh, I'm sorry.
Your indulgence question for these two, what time frame would you recommend? When does Jack need to have this report ready for circulation?
The task force report, I'd like to see it ready for circulation as soon as possible after the November election. We've got a lot of new people. I think.
But not prior to that?
It could be prior, but I want to make. We could.
November's good.
November.
That's why I pressed him.
But I anticipate between several of us that we will have to visit on a constant basis with all 90 legislators,
Of course.
And I think that at least as soon as is practical after the November election, everybody's going to take office is going to get a contact and get this task force report there.
I have a question for it. I'm just going to plead ignorance on the process, but we have 1,200 plus licensed pest control companies, but throughout the state of Arizona, you've got hundreds of political subdivisions. You've got state, county, city, municipalities. Is there a lobbying association out there that could petition the political subdivision if they say that we agree with this, we want these changes?
And the wisdom of your question is very good because Courtney and I happened to talk about that just this morning. The other part of this, and I didn't mention, is smoking out the opposition. Where are we going to, and we need to reach out to them. The most powerful, I shouldn't say that, next to Farm Bureau, Western Growers, and people Courtney represents, one of the most powerful lobbies across the street are cities, municipalities. They carry a lot of weight. And so we will have to certainly reach out to them as well so that they understand and accept. Yes, absolutely.
Well, I would, maybe this is inappropriate, but since I represent a political subdivision, I'd like to be part of that process, bring the information to those individuals. So,
Totally appropriate.
Okay. So, I guess that's part of B under 8, which is review organization. Well, I don't know, I think that's kind of an organizational configuration. It's keeping them as a separate on paper, but we've integrated, we're integrated. Our licensing folks are licensing folks. The only place that hasn't been integrated is compliance. And that's because they're doing very different things.
You've got a track record, Jack. I think you should, it's a successful track record, I understand it. You should include that in the report. As a part of the information of the conglomeration.
All right, any other suggestions?
on the report too, I know your inspection staff is pretty young right now. Are you going to include recommendations on funding to improve that?
At this point, no.
I was just wondering, just for the public, because we're helping too, so for the record, when this comes to fruition, what is OPM called? Is OPM called Arizona Department of Agriculture Office of Pest Management, or are we simply called the Office of Pest Management? Because I haven't heard what we would be called.
Robert Schuler, what do you call now?
Arizona Department of Agriculture Office of Pest Management.
The statutory changes that I would envision are relatively minimal. They are, you remove the sunset period or whatever it was that said for 2 years. First, you remove that, so that makes it permanent. And the modifications that you want to make in statute, you were actually doing them already in statute in 32. Now then you transfer it all over to 40. So you just make your changes in 32. So from my view, unless I'm missing what you do, Jack, which I don't understand completely, I'll guarantee you that, is there should be no operational change in what you've done for the last year. There would be only the removal of that sunset, and all the reforms that Joe referenced would be made in 32 instead of making them in 32 and moving them all then.
And actually, that, I'm sitting here thinking about that. Actually, may make it easy when we become one. I mean, when we've all come together and some kumbaya, because we made the changes in that Title 32, we just need to renumber it, basically, is all we're doing.
And this may seem like a small point, but, and Casey, correct me if I'm wrong, but the drafting process of actually striking them out of 32 and putting them into 3 would double the length of your bill.
Yeah.
When you double the length of the bill, people get real nervous.
Question? Because my ignorance of the process is what I saw. We don't move into Title 32 into 3 now, but we do it 2 or 3 years down the road. What's the difference in the length of the bill? Is it still going to be wrong?
Yes.
I mean, I don't know how that would.
Robert Schuler, that's a good question, but I think then all you've got to do is strike and make it a 3 as opposed to renumber. But I could be wrong on that. I mean, it's an excellent point.
The other advantage would be after that experience and continuance of stakeholder processes, we're going to have consensus. I mean, it'll be a slam dunk and we'll go across the street. And by consensus, I don't mean it's unanimous and everybody's happy, everybody got what they wanted. But consensus on this kind of a bill is, and quite frankly, we don't have it. We won't have it by session. The task force, it just evolved. I mean, there's a lot of players. There's a lot of people. It's diverse. We're not going to have it. And after 2 or 3 years of going through that, the rollover of 32 to 3 would be like the attitude of their wife, why didn't you guys do it before?
Well,
I mean, and that would be the question that I would.
If that circumstances arises and we're doing that, it will be viewed as almost a housekeeping.
Exactly.
Thing. So that's the answer to why it's going to be much simpler downstream.
Yeah.
That's precluded on the fact that it succeeds initially, and then relatively everyone is happy with how it's being run in the interim.
Casey?
I just have a question for Mr. Sig and for Mr. Schuler. Right now, Office of Pest Management and Department of Agriculture are 2 separate legal entities and working together. My understanding is if we left OPM in Title 32, there would continue to be 2 separate legal entities, 2 separate agencies instead of 1 agency. Is that what you're envisioning, or do you envision them to actually be 1 agency in 2 different titles?
I would envision them functioning just as they are at the present time, but the authority for OPM would arise from 32, not 3, just as it is now. But I defer to my legal counsel here.
Robert, that's certainly my intention. That's why I keep wondering, though, especially from Casey and from Jack and Vincent and Robert, is there an operational or impact on leaving it as it is that I'm unaware of? I don't think there is if you just remove the sunset and make it into, from an operations standpoint, I don't see why it would be there.
Jack, I guess my question is, currently, Jack Peterson is the Director of Office of Pest Management, not Mr. Butler. So when this comes to fruition, will Jack Peterson still be the director, or will it be Mr. Butler?
Under my view of it, Jack Peterson would still be the director.
All right. Need to
He
chew on
would
that.
also get an increase in salary, so
Okay, I guess maybe what we need to do is I need to get going. I actually did start writing some stuff, because it's, not many sort of bringing it up. But, need to get writing. If there's any suggestions you have or whatever, please let me know if there's anything specific. I'll make sure to include it. Next we have call from public. Okay, hearing none?
Are you moving towards a wrap? Not just for today, but I mean, finishing up?
Well, that's next on the agenda, call from public, to set the next meeting date.
Okay, will there be?
Well, I guess I'll put that out to you guys. What do you guys, do we want to meet to talk about the report, or,
My suggestion would be that when you have a substantially completed or draft form of the report, it would be.
Okay.
But I don't see any reason
to set a
to
date?
meet prior to you having it.
Okay, so let's leave that to the next meeting in limbo at this point in time. And,
Before November.
what's that?
But before November.
But before November, yes, definitely. It's July. It'll likely be, my guess is it'll be September. Okay?
One more thing of note, we have a national celebrity on this in a National American Vegetable Grower magazine. Here's a picture of our own John Bolts. And
Good picture. It's a lot of
sweet corn.
It's amazing what they can do with Photoshop. I grow no corn, and that'll teach you to sign your rights over to Monsanto.
Well, my question is, certain budding politicians rent children for their ads.
John, would you like to elaborate on, are those actually your children?
Those are actually.
Yeah. Nice looking children.
All right.
That's a pretty good agent, too.
Yeah.
That's very nice. Congratulations. That's cool.
It is a really nice ad.
All right. With the next meeting date in limbo, we'll just call the meeting adjourned. So thank you, everybody, for coming and your time and effort.